on Law Weekly, we look at the legality of the continued stay in office of the chairman of the Code of Conduct Tribunal, Mr. Danladi Umar, especially against the background of the corruption charges pending against him. We have some lawyers share their views on when he should stop presiding over cases. Also on the program, the Nigerian Maritime and Safety Agency, NIMASA, and the Nigerian Institute of Advanced Legal Studies partner to train judges on how to achieve an effective admiralty regime, plus our weekly recap of the top trending stories in the news. Hello and welcome to the program. I'm Shola Sheyeli. 2 weeks ago, the Economic and Financial Crimes Commission, EFCC, filed a 2-count corruption charges against the chairman of the Code of Conduct Tribunal, Mr. Danladi Umar. In the first count, Danladi Umar allegedly asked for the sum of 10 million naira from one Rashid Owolabi Taiwo sometime in 2012 in order to show the said Rashid Taiwo a favor in a charge pending against him. In the second count, the CCT chair is charged with receiving the sum of 1.8 million naira from the said Rashid Owolabi Taiwo. The money was allegedly paid through Mr. Danladi Umar's personal assistant, Alhaji Gambo Abdullahi. Now, the case has been assigned to Justice Ishaq Bello of the High Court of the Federal Capital Territory, Abuja, who was subsequently fixed March 15 for arraignment. Against this background, there has been reactions trailing the continued sitting of Mr. Umar on cases at the CCT. Some people feel that it has become necessary for him to step aside, pending the determination of the charges against him. Others disagree, insisting that he can continue to sit until his arraignment. I have the views of some senior lawyers on the issue.
That position is a position of honor, it's a position of integrity, it's a position of someone that can be vouched for any day, anytime. So when there is anything coming near you, like an allegation of corruption, you must avoid it like a scourge. And therefore, you are not supposed to be told to stop to preside over matters. You must at once stop to sit on other cases when allegations of corruption have been leveled against you in your capacity as a judicial officer. That is not to say that that is what the law requires. Now, the extant law is that before a charge can be preferred against a judicial officer, that judicial officer must first of all be tried. I use tried loosely by the NJC. It's a condition precedent for bringing a charge. So if the EFCC is not doing something properly, that's a serious issue. However, I still want to disagree that the chairman of the CCT is not a judicial officer properly so called. And I have known that because sometimes we bring politics into the judicial affairs, we muddle things up and at the end of the day it becomes problem. I remember there was a time when the issue of whether the tribunal is a court properly called, and they went the whole hog to the uppermost level of the ladder, and they said he is a judge. For me, if you look at the Constitution, I can't remember the exact provision. It's towards the end, around 395 or thereabout. The judicial officers in this federation are listed there. The chairman of the CCT is not one of them. So, for that purpose, it should not be treated as a judicial officer. It sits on a quasi-judicial tribunal.
The CCT chairman, from information we have, was earlier investigated. And from that point of investigation, he should have ceased to sit as a judge over people or persons coming before that tribunal until the integrity of his competence to sit is cleared. Now, the issue came up during Saraki, and it was overruled, and he went further to sit over Saraki. And then subsequently, the commissioner came up to charge him to court. So at this point of even being charged, he ought not to sit at all. It is both morally and legally right. Once that issue is raised, the first thing he ought to do is to excuse himself from sitting. Especially when Saraki raised it, he ought to have excused himself until the issues against him are cleared. It is when he is cleared that he can then confidently and in the eye of the public sit as an innocent person. But in this case, he did not. So now that it has come up, he should not, in fact, sit at all, whatsoever.
If you are presiding over a particular case, and you are, and remember I'm talking in general terms, and you are charged and arraigned for some impropriety regarding that same case, it will be inappropriate for you to continue sitting over that case. But again, in general terms, the position of the law is that until you are arraigned, it is all in the realm of speculation. Is there a charge pending? Is there? Until you are actually arraigned, you're not arraigned. And even if you say you have a copy of the charge with the court file and everything, remember, a charge could be filed today, but before arraignment, it could be discontinued. The Attorney General could enter what we call a nolle prosequi. I no longer want to prosecute. Therefore, that charge is no longer validly before a law court. So one has to really deal with the specifics.
It's still speculatory. He has not been formally charged. Therefore, from now till when he's formally charged, he's entitled to sit. That is my candid view about it. However, upon arraignment, I expect him to step down because he's likely to lack that moral justification to sit upon people's cases. Whether NJC or any other body has done anything about it, but I will expect him to step aside for his trial to be properly conducted and for him to also defend himself properly before whatever happens, he returns to bench.